Hello, Mark Robinette here, following up with your questions and answers from yesterday's NADOA seminar. Thank you all again for having me out. I'll be glad to come back anytime. Special thanks to Yoli for getting me set up and for extending the invitation. I'm going to go through these one by one, and I am going to address these as quickly and concisely as I can. First question, can an operator withhold payment for a lack of a tax ID number? I would say that is not a valid reason if they have marketable title. People refuse to give EINs all the time, or TINs, whichever the case may be. Your remedy in that instance is to engage in backup withholding, and I would contact your tax person over that. Talk to your accountant, talk to your tax lawyer. I don't do either one of those things, so I know enough to be dangerous, but I believe your remedy would be backup withholding of 28%, and by golly, if that doesn't convince him to give you the W-9, I don't know what will. Can an operator withhold payment for when the royalty owner has a bad address? I'd say that is a bit of an essential term to the lease, because part of it is you pay royalty. There's a lessor's address, and if the lessor's checks keep coming back as undeliverable, unclaimed, what have you, that's a pretty good indication that perhaps your owner has died or they've moved. The point is, you don't have any means by which to perform the lease. You stand ready to perform, but you can't perform, and I think that's excusable. I don't think you'd have to pay interest or anything like that. I think that goes to the condition of the lease, and the statute is written in a very absolute way, but I don't think that any court would hold you to it, more than likely. All right, what determines a reasonable basis of knowledge for an affidavit of heirship? For this complicated question, but you're always looking for credibility, and more credibility. And how do you determine credibility? Well, what do they stand to gain from giving the affidavit? Do they actually know the deceased? Do they actually know the deceased's family? Are they somebody that they dug up who knew the family growing up and used to come over and play as a little kid at the house once a week, and maybe they don't really know that much about the family? They can say that they've met the deceased, but they don't know much. Do they have anything to back up what they're saying? Sometimes having an interested party give an affidavit, or even a disinterested one that's perhaps a researcher or something, they can attach things that boost the credibility of the affidavit: death certificates, census records, baptism records, probate proceedings. It's okay to have an affidavit with exhibits. I think that's great. Anytime I do an affidavit with exhibits, I try to add exhibits to make everybody's job easier, to demonstrate the credibility of what's in the affidavit. So exhibits are good with information that backs up what's being said. The affiant actually knew the person, and I don't mean just met them once in their life, but knew them. Other means of credibility. I mean, we could go all day long about the person, or they convicted of a felony or whatever. We don't really have the luxury of going that far into it. So I think those are the two big ones to look out for. And a third idea is, well, what do they stand to get out of it? Who is asking them to do this affidavit? You have somebody who's gone out and done some hair finding, is going to get a third of this estate for pushing this through and wants to get paid. You got to scrutinize those more carefully, because the motive there is it's a profit motive, and I've seen many instances where folks like that, they will just jam through anything they can and insist that it's right, and you got to stand your ground on that. So consider who is this person, who's asked him to do it, any backup information that's attached, and did they actually know them? I think those are the big ones. They could be interested parties in the estate. That doesn't necessarily disqualify them. I think most of the time, people who know the family best are the family, and but if they are interested, you might want to have more than one person give you the affidavit. It's okay to ask for multiple ones. The first one maybe gives you the willies a little bit. Maybe you ask for a second one. That's okay. How long should the operator pay the administrator in the state of Arkansas? Well, best case scenario on that, most administrations take less than a year. I'd say if it's gone on for more than a year, you might want to call and ask a question or two and say, hey, what's going on with this estate? This has been a while. Most estates, when I do one, I want to get it over as soon as possible. The absolute soonest that you can get one over with is 6 months after the date of first publication in the newspaper. But in practical matter, that doesn't happen. Usually there's another month or so lag. So, 8 to 9 months is pretty normal for an estate. Almost all of them are done within a year. If you got one longer than that, there's some things going on, and you want to make sure that it is in fact still open. Certainly, you don't have a duty to discover that. I mean, you could go on until you get the ownership change, which usually, if the administrator is doing his job, they're going to send you a copy of the administrator's deed to the heirs. And when you have that copy, it's time to, you want to inquire of the administrator, do I need to keep paying you here? Because once they're discharged, you don't pay them anymore. So, I mean, that's the real answer here. How do you discover when they're discharged? They're usually going to be discharged within, a month of that distribution, that final distribution. In an ideal world, the administrator would be on top of it and would be talking to you and giving you the ownership changes. But at some point, you're going to send a check and it's going to come back in the mail or something like that. At that point, something's changed. So there's no perfect way of doing it. I could just tell you once they give you their letters and things are going on, the estate's moving forward, that is the, you got to pay them during that, and then, whenever you finally get that order discharging them. Or for that matter, you might just get something from the administrator saying, well, we're about to close the estate. Go ahead and stop payments. Because at that point, the administrator has no needs for the funds. And in fact, the administrator might tell you that from the get-go. Yeah, it's under administration, but I don't want to collect this. You just hang on to it. And they'll put it in their accounting and so forth. And, you just hold on to it in your escrow account. In that case, because they voluntarily told you not to pay, you don't have to worry about the interest or anything like that. Next one. Let's see, the affidavit of collection of small estates required proof of notice to creditors, basically running the obituary in the newspaper for 2 weeks in the county where the minerals are held. Can you advise, if this proof is not provided, how hard should a company press to get this, or can an operator process a transfer without notice? Okay, yes, that's all accurate. The notices have to be, first of all, sent to the heirs. That's part of the probate code. And secondly, it has to go in the paper. When it goes in the paper, it's once per week for 2 weeks, 1 week apart. And so that notice, it's important mostly when you're talking about a small estate affidavit with a will attached. Remember, a small estate affidavit without a will attached is just basically an affidavit of death and heirship with a proviso that they may be able to compel you to pay if you don't honor it. Remember, you have a duty to pay marketable title. That's another statutory duty, which the two are in conflict. You go with the more conservative one, which you don't have to pay. They can kick and scream all they want, but if that thing is deficient, you don't have to pay. Now, when the will's attached, remember that will doesn't have to be declared valid by a probate court. So that makes it a much more dicey situation. In that instance, you really want to scrutinize the notice. And if they won't give it to you, you're within your right to say, well, it's a statutory procedure. It requires strict compliance. And because I don't have everything that I need to prove that this is a valid affidavit, that you followed all the steps, I can't honor it. And it's just simple as that. And I think it's best practice to do that anytime the will attached. Really scrutinize it. If they don't give you everything you need, tell them to bring it. I need it. And even beyond that, You may have to scrutinize the will itself. Is it really a will? May not be. Next one. Can probate sans administration, being probate as a union of title, be a substitute for ancillary probate? Well, this is just a confusion of terms. Ancillary probate just means that it's a probate that has been started in a different jurisdiction other than the primary one. So if you die in Arizona, probate the estate there. If you probate in Arkansas, it's ancillary. Ancillary believes from a Latin word that means slave. So think of it as the master probate's over here in one state, the slave probate's over here in the other. So if you lived in Arizona, the master probate would be there. If you had property in Arkansas, you could do the slave probate in Arkansas, okay, the lesser probate. So that's all that means. It's just the difference of jurisdiction. Probate from union of title, that means that you're just probating a will without administration to show ownership in the property. Now, you can do that in any jurisdiction. You can do that in the primary jurisdiction. You don't have to ask for an administrator. You can then come here and do it here and not ask for an administrator or personal representative. It just means that you're admitting the will to probate. So an ancillary probate can be a probate as union of title. It could also be a probate with an administration. So they're just two different concepts. But certainly, with the spirit of the question here, I think what's being asked is if you have an administration in State A, do you have to have an administration in State B? And my answer to that is, if the administration is over in State A, property's been distributed, and especially if it's been more than 5 years, you can probate it here in State B, Arkansas, if it's Arkansas State B. You could probate it here, and after 5 years, you're not allowed to have an administrator except if it's related to a petition to determine heirship. So at that point, you just pay the will devisees, whoever they may be at this point. I mean, it's perfectly okay. The only time you have to be suspicious of an ancillary probate done as a union of title is if it has been done within the 5 years for administration. But even still, you're going to have a potential administration later. You don't really have a duty to go out there and, it doesn't make the title unmarketable. And you can pay based upon that, but it would be a little funny if they did that, and you might wind up later being contacted by an administrator or personal representative if they show up. I think it also probably, if there's been a proceeding in the other state, I think I would want to see that just to see how it wound up. But you can go into minutiae on this. You can go forever and ever and ever, and never stop trying to eliminate every risk. I think in most cases, a simple probate as a union of title, you can just go with it until you hear from someone who's an administrator saying, hey, we're coming in now and taking this thing over, and we want you to pay us. So I would say by and large, I just honor them, and if someone shows up later who wants to be the personal representative, great. Because just because you're the personal representative over in Arizona does not mean that I, as the person overseeing Arkansas property, have to worry with you. Now, if you've been contacted by an administrator, and that administrator in that other state, well, we can get into hypotheticals all day long. I think if you got a real specific question about this, just email me. But in general, they're perfectly valid as ancillary measures. Okay, certification of trust. Should it be recorded in the county where the real property is located? You know what? No, not required by statute. All you have to do is have a statutory form. It has to comply with it. If it complies with it, then you can honor it and you're protected. It doesn't have to be recorded. Make a copy for your files. I think that this has become popular in title opinions to obtain and record, but really it should just be obtained. You don't have to record this, because then you're going, having extra steps here. I know we all like to have as much information in the public record as possible, but technically you don't have to make them record it. Is it necessary for a surviving spouse to deed to heirs? If the surviving spouse agrees, since it's a life estate, do we pay the children equally? Well, if that surviving spouse does not want their dower interest, they're going to have to do something to disclaim it, because after the owning spouse passes away, the dower interest becomes consummate, which means they can't walk away from it. It remains for 7 years. After a conveyance from one of the heirs convey it. For 7 years they can recover it. But in most cases with minerals, the heirs are just going to be there collecting their checks, which means the spouse is sitting there with this consummate dower interest. So they just can't abandon it. It's an interest in real property. You can't abandon interest in real property. They're going to have to do something. The spouse is going to have to quit claim it to the heirs, file some sort of unilateral disclaimer in favor of the heirs in the records. Something has to be done on record to extinguish that interest. So second part of the question, surviving spouse agrees it's a life estate, you pay the children equally. Well, I think what I'm being asked here is, if the surviving spouse wants their dower interest, what do? Well, surviving spouse, depending on the character of the dower, most of the times is third for life. Yeah, they get a 1/3 life estate. What's left over, the present interest, the 2/3, that gets paid to the children, yes, equally in proportion to their share of intestate succession. So if you have 2 kids, they'd get half of 2/3 each. Then they would have a reversionary interest in the spouse's life estate of 1/2 of a 1/3 each. So one thing to keep in mind, certainly you could kind of run naked on this if the surviving spouse is agreeable to their life interest and the children understand that. The likelihood of later them trying to set that situation aside, I mean, really they can't. I guess what I'm getting at here is that you're supposed to formally assign the dower. So if there's no formal assignment of some sort where the children say, we hereby do assign to, surviving spouse this dower interest, I'm not sure what the ramifications of that would be. You're entitled to 1/3 of all the rents and royalties for life. So, the fact that you don't have a piece of paper showing that, I don't think that's going to be a problem. I think it might be a problem if the heirs sold the interest, and then you have someone else coming back saying, hey, what's up with this? Well, why are you giving 1/3 of the royalties away? That might be a problem in that instance. I mean, I would ask them to do the formal assignment of dower if you want to get technical about it. That might be a markability of title issue. But I think by and large, most of the time, you want to keep things moving, you want to get interest transferred, and you have to assess the risk versus the effort, and versus how much goodwill are you going to give away if you're too hard on them. It's many times they're just business risk decisions that you have to take. There's a lot more on dower and assignments and everything in the written materials. If you don't have those, they're posted to my website. You can get them there. So I do want to mention that the webinar I've reposted on my website along with the link to the materials. And then, of course, this will be posted as well. You can watch it from your phone or wherever. It was good talking to you all. If I could ever do anything for you all or your owners, just let me know. I draft all kinds of documents. I find all kinds of ways to skin that cat and get that interest transferred where everybody's happy. So I'm quite open to any referrals you can send my way. Thanks again. Y'all have a super weekend.